Well, welcome everybody to the Rental Property Owners Association. Conversation this morning is about an update on evictions in Michigan. So I guess a little ground rules at first. Everybody else is muted for the most part. We're going to take questions once we get through the first part of the presentation. So we're looking at probably a total of 30 minutes or so this morning. And we're going to give you all a chance to ask questions up until that point of time. And when you do have a question, you can use the chat box. I think that'll probably be the easiest because it looks like we have several people joining us this morning. So I might get a little crazy trying to look for raised hands and that kind of thing. So I guess with that, I'm going to introduce Haley Clough. She's an attorney here in Grand Rapids. Does a lot of legal work for rental property owners and real estate investors. And you might want to talk a little bit more about other things you do too, Haley, is so that everybody kind of knows your background and what you're mostly working on.
Sure. So lately, landlord matters and real estate matters have taken up at least half of my practice. In normal times, I also do a lot of estate planning and probate work. And I'm part of the corporate group at my law firm. So I do a lot of general litigation, business litigation, and business transactional work. But like I said, a lot of it right now with everything that's going on has been real estate and landlord tenant work, making up about 50% of my work right now.
Great, and I want to take this chance to publicly thank you for all your help with the RPOA too, and working through all of this stuff. It's been crazy. Haley and I have been in communication since the latter part of March, all the way up until just recently with the latest, CDC moratorium. So we're trying to stay on top of all this to make sure that we do the right thing and get the right information out to our members. So I guess my first question for you, Haley, is we all know, at least some of us know, that evictions are being done a little differently now, and thought maybe you could kind of step us through the current process for how evictions are being done and if there's any differences between the courts that you've been in contact with.
Sure. So there's an administrative order out that dictates that the courts change their normal summary proceedings procedure. Instead of having a one summary proceedings hearing at which either your tenant would show up and consent or show up and ask for a trial, or at which you would have a tenant that doesn't appear and get a default, you actually have a 7-day mandatory adjournment. Then you have your second summary proceedings hearing after that. And that summary proceedings hearing is handled more like what most landlords would be used to in the traditional one-time summary proceedings hearing. There is a rule right now under the administrative order in place that a tenant who is personally served with the summons and complaint, and they are set for that first hearing, if they are personally served and they fail to appear, you can still get your default judgment at that hearing. But for the most part, we're getting a lot of 7-day adjournments. I found that nearly every court is adjourning just for exactly 7 days. So they don't seem to be so clogged up that they're not able to continue to schedule in a pretty quick manner. I'm not seeing like 2, 3, 4 week adjournments. I'm just seeing the one. So that's good news. Of course, we're able to conduct hearings now via Zoom or in person. Clay, you asked about different courts handling things differently. I'm seeing less of a difference between how courts are handling the new administrative order and more of a difference between how judges are handling it. So for example, at 61st, you could be in front of a judge who is allowing all of their hearings to be held via Zoom, as long as the attorney makes the request. You could also be in front of a judge at 61st who won't allow any Zoom hearings, so you have to be in person. I personally prefer Zoom. It cuts a lot of the travel costs for myself and for my client. And it also allows the ability for the attorneys to perhaps charge their clients a little less, because while you're waiting to go on, you're not just waiting in a courtroom, you're waiting in your office. So you can get a little bit of work done, perhaps answer emails, and you don't have to bill your client for that waiting time, which is beneficial. Along with that administrative order that allows for Zoom hearings and requires 2 summary proceedings hearings, there's also a priority schedule set forth in that administrative order. And Clay, I know you were pretty involved in helping the court develop that, or helping the state develop that priority scheduling.
Mhm.
What I have found so far is I get a lot of questions from landlords before they file their complaint, wondering if that priority scheduling, if they fall at the bottom tier, you know, in 4 or 5 or below that in their priority, which for most tenants or for most landlords would be straight termination cases where there's a termination, but it's not for criminal activity. They're just ready to get a new tenant in there. Clients call me concerned that they're going to have a significant wait because they fall at the very bottom of that priority. I knock on wood, but so far what I've found is there's not a significant wait. The courts are still able to process hearing dates pretty quickly. You know, you may have 1 additional week that you'd have to wait, but it's nothing crazy. It's not the months-long wait that I think people thought would be happening. Now, I do think evictions are really going to ramp up, whether it's at the end of this year or once the CDC moratorium expires, beginning of next year. And at that point, I think the priority scheduling may play more of an issue, but as of right now, I'm not seeing any significant waits. So that's nice as well. As far as really the only other change I'm seeing, without getting into the CDC moratorium yet, because I think we're going to talk about that in a bit, is that because we have an EDP program that does not require that a tenant receive a judgment in order to get funding, a tenant could appear to an EDP HARA or an EDP administrator with just a demand or just a summons and complaint. They don't need the judgment. The process has become a little bit less adversarial. That's not to say that you don't need to continue to have an attorney to protect your rights as a landlord. I actually think for a lot of reasons that's more important than ever, because there's these form documents that you need to make sure are tailored to your specific situation, or else you could have an issue down the road. But the actual process of working from that first summary proceedings hearing through attainment of whether it's a judgment or a settlement agreement or conditional dismissal, it tends to be much more, there's a lot of more working together. There's a lot of collaboration between the attorney, the landlord, the tenant, and then the EDP HARAs, the administrators who are handing out the money. So I find that process pretty helpful. Everyone's been good to work with. There's more of a sense that people all have the same goal if the EDP is an option for a landlord, because it is both beneficial to the landlord and to the tenant. So in that sense, it's not quite as adversarial as your normal landlord-tenant cases would be.
So when you go to the first pretrial hearing, the first summary proceedings, is someone from a HARA participating in that call, or is there someone else involved, or is the judge involved in that first pretrial, or is it, you know, who's involved there, and is money being offered as a tenant then being explained that there's eviction diversion program and money's available, and et cetera, et cetera?
Yes, so it appears that the entire purpose of the first hearing is to bring all the parties to court, show the tenant that there are individuals willing to help them, that there's money available, and explaining that process to them. So beyond that, you really don't have a lot happen. I haven't had anyone consent to anything happening at that first hearing because there's generally not been enough time in order for the funding to go through. But there usually is someone from the EDP. There's nearly always legal aid who are there, and of course they are keeping an ear out to listen to see if a tenant has a defense to the case. But for the most part, they're listening to hear if this is perhaps a person for whom the EDP would work, if it's an option for the landlord to help them walk through that EDP funding process. And yes, it's still in front of a judge. A judge still has to give the adjournment. So generally you'd have the landlord, their attorney, the tenant, the judge, and then legal aid, and someone on behalf of either the EDP program. In Kent County, it's Salvation Army, and then someone from MISTA. So you do have a large group of people at that first hearing, and then it tends to be the same group of people who appear at the second hearing.
Okay, sounds good. And do you have a feel for how many cases, I mean, at least the ones you're working with, that get resolved before even the first pretrial hearing?
It's very rare, and it's not for lack of trying. It is more because the process of getting a tenant through the EDP program to the point where the landlord, it's now on the landlord to confirm what the tenant has given to the EDP administrators. That process takes longer usually than a week. So the tenant needs the 7-day demand in order to even start the process of seeking assistance. Usually we're in court before you would have a situation where someone could already have signed a settlement agreement, checks, being processed. So it's not that it's not possible. It's just that process tends to take too long. My office sends out for my landlords who would like to participate in the EDP, and given the CDC moratorium, most landlords are, and that's generally what I'm advising. We send out a cover letter indicating that the tenant could provide simply the notice to an EDP administrator. We give them the screening number. And so there's certainly an attempt to get that ball rolling, but it usually doesn't get all the way through by the time you have that first hearing. So I tend to see the first hearing and even the second hearing before it's resolved to the point where funding is coming down the line.
Okay, great. Well, for those of us who have joined us who don't know what EDP means, it's Eviction Diversion Program. It's the funding that was made available. It's federal funding that came down to the state of Michigan, was allocated under MISTA to disseminate across the state to various different communities, and there's differing amounts depending on how large the community need they at least projected would be in each of the counties. Haley mentioned something called a HARA. That's a Housing Assessment and Resource Agency, and there is one in each county, and it happens to be Salvation Army in Kent County, but it may be different in your county. So if you're not connected with those folks yet, and the reason why I think it's kind of important to do that, if you can connect with a HARA in your local area and get some information from them, because our local HARA here in Grand Rapids provided information that we could provide to our members that could then be sent along with a 7-day demand for possession for non-payment. So the tenant is aware right up front that here's an option for you if you don't think you can pay the rent or you're struggling with situations. So, and just kind of an FYI, not as much of that money has been used as they thought would be used right out of the gate. It's only been about a month and a half now that it's been available. But also good news, I guess. I just read today that Kent County is going to be supplementing that to some degree. I believe $1 to $3 million is what it looked like to me for rental assistance to kind of shore up the eviction diversion program here in Grand Rapids if funding starts to get low. But I think the county commissioners are looking at it, and at least here in our area, are looking at it as a backup for if and when EDP funds run out. But I know across the state, it seems like that the funding is going to be available, but it's only available through, officially at this point, through the end of December. So I think, Haley, you made a good point that we're probably going to see evictions ramp up a little bit because some of the support from the federal government is gone, or it's not as much as it was, and that with the CDC moratorium rolling around in January, there's going to be a lot of folks who, unless they come up with some additional funding of some sort and extend the eviction diversion program, we're probably looking at a little bit of a struggle for a lot of folks when January, February rolls around. So I think that's a good point on that. How are other evictions going that aren't related to non-payment of rent? Are those going pretty much normal?
For me, they have gone, for the most part, normally. Now, the requirement that there still be 2 hearings, even when it's not a non-payment case, still applies. So for the most part, I've had a few termination cases, meaning cases where the landlord just wants their property back, either on a month-to-month termination or their release violations. I've been able to process those in the normal amount of time, maybe given an extra week or 2 because you have that 7-day adjournment. So far, those have been going normally. Now, I was actually waiting for a hearing yesterday while I was on Zoom, and I had a woman who I was listening. I wasn't involved in the case, but I was listening, and there was a tenant representing herself, and she made an argument that the CDC moratorium applies to straight 30-day termination cases when it's not for a breach of, or rather it's not for criminal activity or something like that. Without going into the long analysis of that, I don't think it's correct, but I will say she got far enough for the judge to give her a 2-week adjournment. So that was really interesting to listen to. There's definitely an element that all the orders that are coming down right now, whether it's at the state level or the federal level, seem to be fairly hastily written. And so there's a lot of holes that need to be filled, but because they apply for such a short period of time, I'm not sure we're ever going to get the case law to establish exactly how to interpret some of these ambiguities. So as far as termination cases go, we are just proceeding as normal, and so far have gotten the normal result. We've gotten a judgment with 10 days to vacate in all of my termination cases.
Okay. Yeah, you mentioned the CDC moratorium, and it did seem very cut and dry to me when I first read it the first time. I thought, wow, this seems more specific and to the point than the state of Michigan's moratorium that went on for several months, which pretty much left everybody hanging out there, regardless of what kind of eviction case you had, unless it was an extreme situation. But have you had any situation where the courts have said that, I guess,
meeting for RPOA.
that
That's how I
your particular case is something that needs to be delayed longer because it wasn't a payment of rent or something that was an urgent need?
I have not. The one situation I have had come up was a case that was filed in 61st District Court, which is probably the most high volume court that I regularly practice in.
That's free.
The clerk told my legal assistant that she was able to schedule that first hearing sooner than she otherwise would have. It was a termination case. And the reason she was able to do that was we attached a police report to the complaint. It was a termination for criminal activity, not just a straight termination. So that told me that in 61st, they would have had to give me a later date for just a 30-day termination case. They were able to push it forward because it involves criminal activity. So I think in the courts that have a really high volume, you're going to see more of an emphasis right away on that priority, the priority scheduling that is in that administrative order. I think it's 2020-17. Other than that, I've not experienced any delay from the clerks and the judges.
I was wondering because we were successful in the last go around of the Supreme Court's administrative orders to allow for submittal of a request to expedite a particular case depending on the urgency of it. And I just wondered if that was working or not. It sounds like it is, so that's good.
Yeah, it sounds like it's working. It's being interpreted properly. So that's priority list or scheduling, I think, is working.
Okay, good. Well, I think it's even more important, as you noted, when you have courts that have a large volume of cases that may be, in larger cities, may be more true than not. And I believe there's still a moratorium on evictions in the city of Detroit, even at this point. I'm not sure of the specifics of that and how far that goes, but that may change too.
Right. I've heard that rumor as well. I don't know because I haven't had one that I've had to file. I had one case in Detroit where I had to send a notice to quit. but the people ended up moving out. So not having to file means I never found out how that particular court was going to handle it.
Okay, I see. Yeah, and I guess just as a point of a note, I've had a question the other day from someone who said, well, my tenant moved out, but they still owe me rent. Can they still get eviction diversion EDP funds to support them? And the answer is no. Once the tenant has moved, as far as I know, that opportunity is gone. You have to take that tenant to small claims court. And then even if you get a judgment, my understanding is EDP funds could not be used to pay that judgment either.
That's correct, Clay. My understanding is that the purpose of the EDP funding is to keep people in their current homes. So for a tenant who has moved out, while the EDP funding, of course, helps to compensate landlords because it's not the main purpose, they're not going to allow that funding to subsidize the landlord in small claims.
Mm-hmm. Well, and I think that based upon the information I'm seeing, because we're involved with the local eviction diversion program with the HARA here in town, and it looks to me that we're trying to be very, very flexible on the use of the funds and eligibility for the funds. For example, initially when the guidelines came out, it sounded like that the HARA wouldn't pay more than 150% of fair market rents. But the latest determination is, well, so it made you sound like they wouldn't participate in helping with someone if the rent was more than fair market rent or 150%. But they've kind of adjusted that now, saying they'll pay the portion of the rent that's up to the 150% of the fair market value or fair market rent, and then the tenant would have to be responsible for the additional amount above and beyond that. So that was a, you know, I think it looks like to me they're shifting, keeps shifting things a little bit as needed in order to help more people faster and better, I think. So that's
I found the same thing to be happening. And I think the EDP HARAs, at least the ones I've been working with, and the MISTRA representatives have really been great in providing a few options to landlords and tenants so people can decide how to proceed. While that can sometimes be confusing to tenants and landlords, having an attorney involved, you know, gives you a good idea of how you want to structure, whether it's a conditional dismissal or a settlement agreement, you know, which option do you want to select from the HARA, and then how do you incorporate that properly into the document that will ultimately resolve the case. I found that there's quite a bit of flexibility. I've been drafting my own conditional dismissals rather than using any kind of form provided by a HARA or anything like that. And so far, I've not been met with any opposition. They're really, if the general spirit of the program is upheld, they've been quite flexible in granting the money and allowing the case to be resolved through the funding program.
Well, that's good to hear, because initially it sounded like they were going to force us all to use a specific form, and that was
right.
I've not. So.
Yeah, I haven't found that. Now, I don't know if you're unrepresented, they may, because they may just not want, you know, a layperson drafting their own form. I don't know, but I've been able to make revisions to the forms that are generally provided and haven't been met with opposition. So, okay. and there have been. I've found in almost every case where I've received a form, just a standardized form, there has been at least 2 or 3 things that wouldn't have applied to my tenant's case and could have been a problem if they were put on the record, whether it was by filing the conditional dismissal or entering into a settlement agreement. There were provisions in those documents that would have been an issue. They just didn't apply in my client's case. So it's good that they are being flexible in the wording, because most attorneys aren't going to tell their clients to sign something that could create further confusion in their case.
Sure. Well, I think this is a good place for us to stop and start looking at some of the questions. I've got several here, so I'm gonna start throwing these out there and see if we can get some quick answers. The first one is, what about 38th District in East Point, Michigan, not scheduling any eviction cases? What happens if at the first hearing we can prove the tenant has ignored or stated they are not interested in pursuing eviction diversion program funds. But why wouldn't this be a violation of the CDC affidavit and allow eviction and allow the eviction to continue? So it sounds like, well, the first part, I'm not sure. It's probably two different questions. Why wouldn't a district court be scheduling cases? Any idea?
My thought is this is probably going to your question earlier that you asked me, like the city of Detroit not hearing eviction cases. I don't know. None of the courts that I practice in are refusing to schedule cases. Now we did have one local court that requested further guidance from the state before they had like a month where they were still saying they were closed. And they wanted additional guidance of which employees I think they could bring back. I believe that was the delay. So I don't know. I don't practice in 38th District Court with any regularity, so I don't know how they're set up there, but it could be the case that they are skittish about reopening the actual building for whatever reason due to COVID. So that could be what's happening there. But again, I don't know. I haven't heard a case there.
Well, I know there is some allowance within the administrative orders from the Supreme Court that allows courts to decide when and how they're going to hear cases. So
right.
There's quite a bit of flexibility there. The other part of the question was, I guess I'll just restate this a little bit. Can you continue to pursue an eviction if a tenant turns down the EDP?
Yes, you can. Now, the tenant should not be able to sign that declaration. One of the bullet points on the CDC declaration states that the tenant has made their best efforts to receive financial assistance through the government or otherwise. If the tenant is refusing to participate in the EDP and they have provided that CDC affidavit or the declaration, they've probably committed perjury. Now they're not going to get in serious trouble for that because the judge is going to cut them some leeway, but more than likely what should happen in that case is the declaration should be set aside or formally withdrawn and the case should be allowed to proceed.
Okay. There's another question that probably is from a tenant or I'm not sure someone is. What about landlords who will not properly exterminate things at property? I guess they must be talking about pests, et cetera, in that situation. I think that's probably more of an issue between the landlord and the tenant, because most of the, at least my understanding is most of the communities have the international property maintenance codes, and the property maintenance code require the tenant to participate in the eradication of pests. But that may be an issue between the tenant and the landlord needs to get resolved. I don't know, Haley, if you have a thought on that one.
No, you're right. The IPMC applies. It's been adopted by the city of Grand Rapids and the other municipalities in this area on this side of the state. So yes, the tenant is required in certain cases to participate in the extermination process. So you don't necessarily get to push that all back on the landlord. But nothing in the current orders, whether it's the administrative orders or the CDC moratorium, nothing circumvents defenses or affirmative defenses. So a landlord or a tenant who has a defense or an affirmative defense to a case, all of those still apply as normal.
Okay, yeah, that's what I was thinking as well. Here's another question. Regarding a waiting period, 60th District Court in Muskegon, an attorney submitted paperwork to the courts over 2 weeks ago. They haven't received a response yet or a court date. It sounds like this question is basically asking how long is this going to take, and it's delayed 3 weeks or more, I guess, in this particular case. Do you see any of that happening, or?
I haven't in the general Kent County and surrounding areas. I think in Muskegon, I want to say the last time I had a landlord-tenant hearing there during non-COVID times, there was more of a delay than I would generally experience here in obtaining a court date. So that is probably a function of how busy they are in Muskegon and if they have a shortage of clerks. I know there are a shortage of clerks all over the state because many clerks are at home right now teaching their kids and staying with their kids who can't go back to school. So it's probably a function of that. I've not seen such a delay in my practice.
Okay.
So I don't know.
Another question. What if a landlord chooses to not evict for non-payment of rent and instead just chooses to wait till the end of the tenancy and just evict to get possession? Do you see any issues with that? I guess that this landlord may be thinking, I don't really care about the past due rent. I just want these people gone for some reason.
Right. So because of the protections afforded under the CDC moratorium, it would not be the case that you could ask for a termination and money. Once money becomes involved, all the protections in the CDC moratorium apply, because the idea is that if you're asking for the money and you're evicting, it's going to be considered a non-payment case, even if it's actually legally a termination case. All of my cases that have been termination cases, whether for cause or as this individual is asking month to month, have gone through the process normally. The only difference is that you do still have to have the two summary proceedings hearings, the first hearing and the second hearing. After that, they proceed as normal. However, I did mention yesterday afternoon that someone defended themselves by stating that the CDC moratorium applied to a straight termination case. Now, the CDC moratorium states that certain evictions can still continue. Evictions that are not based on non-payment, and then they list some. One of the factors, or one of the reasons why you can evict someone, is for breach of contract. Now, if you have a contract, a lease agreement with your tenant, and they are month to month, your lease is going to say that either party has the option of giving 30 days notice. If it is the landlord who gives 30 days notice, that tenant must vacate upon 30 days. So if, as the landlord, if you followed the procedure properly, you've issued a 30-day notice, and then you've had to file a complaint because your tenant failed to leave, your attorney or you should argue that the CDC moratorium still allows breach of contract termination cases, and once your tenant failed to vacate, they have breached their contract. I don't think that landlords should be receiving any pushback on month-to-month terminations. Like I said, I have not so far, but I did overhear one that got set for a third hearing. So it could be something that we're starting to see, but my guess is that the interpretation is going to be that the CDC moratorium clearly was intended to apply to non-payment cases, and that if you give someone a notice to quit and they don't vacate, that's a sufficient breach of the contract in order to allow you to proceed as a landlord.
Yeah, okay, sounds good. Also, we heard from a gentleman named Drew that the 36 in Detroit is not scheduling any cases yet, so it sounds like the moratorium there is still on, and that's what's happening in the Detroit area. Yeah, it answers the next couple of, it says that Detroit does not have an official moratorium. They're just not scheduling anything or scheduling very little. So that's kind of the scoop there, it sounds like.
My guess is that that has more to do with how Detroit is interpreting their, how Detroit is interpreting the stay home requirements still, or the work from home requirements, that if you can, you still should. And for whatever reason, they're not bringing back enough clerks or district court judges to hear the cases.
Yeah, I'm gonna have to dig into that a little bit more myself and see if I can find out what's going on over there. Here's a good question. I think I can answer this one too. Does a landlord have to file an eviction case in court in order for the tenant to be eligible for the EDP funds? No, they do not. In fact, it starts with the demand for possession for non-payment of rent. So as soon as you send that to the tenant is then eligible to call the local HARA or whatever source is available there to get the eviction diversion program funding started. So that was the good news, something that we negotiated up front, which is, as you probably know, a lot different than what it normally is. As in the old days, for a lot of support from different agencies, they had to have an actual case filed and a summons sent out before the tenant would be eligible. So that's what the scoop is with that. If a tenant submits a CDC sworn statement, at what point must the eviction process stop?
So my understanding, and this is what I've had success arguing in court, is that the process can continue through the time that the landlord actually requests an order of eviction. The CDC moratorium states that it is prohibiting evictions, not eviction filings, not eviction cases. Now, the only time that this may be tricky is if you have not even filed your case yet. If the landlord hasn't even filed their complaint and they've already received a declaration. In that case, I would just suggest that you call an attorney because it's going to be a case-by-case situation.
Okay.
However, if you've already filed your complaint and you receive the CDC declaration, generally what's going to happen is you're still going to go to court for your hearing. The judge is going to ask the tenant about the declaration, at which time you may be able to challenge what they've stated. For example, I was able to receive an order that a tenant must pay $3,500 within the next like 5 or so days because they swore under oath that they were making their best efforts to make payments. They had attempted to tender a personal check to the landlord. The landlord's policy, because this person had already bounced checks, was no, we can't take it. So the tenant said, well, I have the money. I tried to pay it. And the judge said, well, that's fine. Then give us a certified check within 1 week. And then your declaration will stay in effect, which is what I had requested. So there is a chance to push back on those declarations if there's an issue. Generally, what the court is going to do, though, is kind of go through that analysis. And then if there is no room to push back, they're going to say, okay, we're adjourning till January. But in the meantime, everyone is still supposed to be working on getting the EDP funding because, of course, the landlord wants to. And the tenant, by signing this declaration, is swearing that they're going to do their best to get that funding. So I think, for example, if you received a declaration from a tenant and then found out that they're not making any effort to receive the EDP funding, I think you'd probably have success in requesting a hearing, in submitting a motion and requesting a hearing from a judge on that issue, and the judge will tell them you have to be actively pursuing this.
So I had another question from a member just recently that asked me, what if I go through the whole eviction process, I have a judgment and the tenant hasn't moved, and now I'm submitting my order for eviction and the court officer shows up and the tenant then presents the declaration right on the day that the landlord's supposed to be moving the tenant out. Do you see that as that timing working for the tenant or under the CDC order?
It could. And what would happen is if you're at the point where a process server or court officer is at the tenant's residence and they're trying to evict the tenant, if the court officer feels that they've provided this and it's legitimate, what they may do is call the judge or even call the plaintiff's attorney, explain what's going on. What would more than likely happen is the judge then would just call a hearing, probably in the next week or so, bring everyone in and figure out if this is a legitimate declaration. If they determine that it is, then that individual cannot be evicted until January. However, again, the individual still needs to be giving their best efforts to obtain funding. So if it's discovered that that's not happening, you could request that the declaration be nullified and the eviction take place.
Okay. Here's an interesting question. We have a tenant who went to the first pretrial hearing, agreed to leave by September 30th. If they don't move out, the court would issue a writ of eviction. This tenant has refused any assistance. Do you think we will still be able to get the writ of eviction if the tenant isn't out on September 30th?
Yes, but the judge will probably make you as the landlord certify or swear that you have not received a CDC declaration. Okay. So the judge has to be satisfied that a CDC declaration isn't on file either with the court or with the landlord, and then they can process the order of eviction. Okay. So when I am submitting my applications for orders of eviction, I'm including certain language regarding neither my office nor my client having received that CDC declaration.
Okay. Next question is it legal to negotiate an agreement with the tenants to get them to vacate property in exchange for wiping their balance clean and not filing against them in court?
Hang on, I wanted to read this one as you were reading it. Is it legal to negotiate an agreement with the tenants to get them to vacate property in exchange for wiping their balance clean and not filing against them in court?
It sounds like the tenant is willing to just leave. They're just saying, can the tenant just leave if you let them off the lease, and everybody's happy?
Right. It sounds like the question is that what you're agreeing to is just to not file in small claims, which yes, that's legal. If your tenant wants to leave and you don't want to file in small claims, you can still go ahead and do that.
Okay. Here's another question too, regarding the current version of demand for possession document. Is the current demand for possession for non-payment of rent different from the old version of the form at this point?
I guess I will have to look at that. There were a few different ones out there through the SCAO website. I do know, if you were a CARES covered property previously, so I think what this question is doing is perhaps pointing out that there's a different demand for possession that you'd have to use if you were a CARES covered property, because the CARES Act required that once it expired, a CARES covered property still had to give 30 days. So you had to demand 30 days to pay. I think that this is what this question is aiming at, but I guess I'm not sure.
Yeah.
I could look at the SCAO website quickly and see if there's more than just the two I'm thinking about, but as far as I know, that hasn't occurred in my cases as far as a demand being inaccurate. We've been using the correct ones depending on the case that we have.
Okay. If I remember correctly, doesn't the CARES Act covered properties, wouldn't that be up as September 30th? And would after that date, you file things as normal at that point?
So I've been looking for that language, because that was my understanding as well, was that there was an end date to the moratorium, but then there was a sunset date on the extended demand period. And I thought it was the end of September as well. Clay, if you have that information and could email it to me, I'd love to look at that, because that came up with a couple clients yesterday. And what they were being told from there was a larger client from their corporate office, I knew was not the full scope. So I was trying to figure that out yesterday. I couldn't find that September 30th date.
Yeah, and it seemed to me that it was related to when the moratorium was lifted, and then you had, at that point, you had to send a 30-day notice. So I think that was the initial thinking, was that, okay, 30 days from the end of the moratorium being lifted, but I would guess it depends how long you wait. So if you wait, if you're on vacation for 30 days and you don't get back to Michigan until October 1st, and then you file your notice, it still has to be 30 days if it was a CARES Act covered property, right?
I actually think that all CARES Act covered properties right now, and I found some authority from other states, because of course the CARES Act was a federal act. It set a termination date, but then it said after the termination, you have to give 30 days. And it didn't say when that additional requirement expired. Other states have interpreted the CARES Act as not having an end date on that 30 days for the demand. In particular, I found some authority out of, I believe it was Pennsylvania, when I was looking at it yesterday. And there, the attorneys and the judges were saying that there's no official sunset date on that portion of the CARES Act. So they're still requiring all previous CARES covered properties to use a different demand to give people 30 days to pay rather than 7. So I think that's another area where there isn't probably official guidance yet. And I hope that there will be soon, because I do know I've heard from more than one person, September 30th seemed to be the date on which it made sense that would be up, but I couldn't find that codified anywhere.
Okay, yeah, I think you're probably right. It might not be. So
Okay.
I'll have to dig into it myself and see what I can find. We have time for one last question. How do the eviction rules apply to Section 8 tenants who don't pay their portion of the rent? Can you still go forward with an eviction in that case?
Yes, I've not had any, Section 8 doesn't seem to stop the EDP funding, and it doesn't seem to stop the filing of the case and proceeding. I think what you probably will find, just as a matter of reality, is that many of your Section 8 tenants who are not able to pay their portion are going to file the CDC declaration, and then you're going to wait till January to actually be able to evict them. In the meantime, they should still be able to work with getting some sort of funding.
Okay, sounds good. Well, folks, I think we'll end it with that. Just to let you know, you can always contact the RPOA if you have additional questions, and if we feel we need to refer you to legal services, we'll certainly do that. If we can't answer the question, sometimes the general questions we can answer. Our number at the RPOA is 616-454-3385. And Haley, maybe you want to offer your services up for folks who feel like they need it. I don't know if you want to give them your information.
Yeah, absolutely. So usually the best way to contact me is at my direct line. It's 616-552-6381. And yeah, I'm fine. You know, your best bet may be also just to call the RPOA and make sure it's not a standard, here's this form kind of question, and then they can refer you to me. But if you know that you have a question that you need answered by an attorney, again, that's 616-552-6381.
Great. Hey, thanks a lot. Thanks everybody for joining us. We may do something like this similar in the near future again, just to keep everybody updated. So thanks a lot, and everybody have a wonderful day.
Great. Thank you.